Jason Watkins?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Watkins, in cause number 23, DCCR 0198, you're charged with the second-degree felony offense of sexual assault of a child from December 25th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
I fully understand.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Understand.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Understand. U.S. citizen.
And thank you. I have to ask everyone that. And did y'all fill out the?
I'm just thinking about that, just we did not.
Okay, so on these documents, there is some information about sex offender registration requirements. And do you understand that as a result of this plea, that you will be required to register as a sex offender? Also, there will be another document that you guys need to sign that just has that specific information on about what those rules are. So when we're finished today, you and Mr. Rojas need to go over that, and I'll just need your signature on that as well, okay? Okay. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Watkins is not competent?
No, Your Honor.
All right, Mr. Watkins, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and y'all get that that one more paper signed for me, okay? Thank you.
He almost didn't want to sign the rejection because it doesn't say speedy trial, so it's gonna just. It's not an issue, but then just.
Okay.
That's a big deal.
It'll be as speedy as we can make it.
She's gonna call me right back and let me know.
Okay. Hey, would you text Charlie? I don't know if he left.
He's in
wanna-
county court too.
Text him.
Oh, okay, okay,
We're ready for him.
okay. I just don't want him to get stuck down there in the middle of something and then him get iffy again. Good morning, sir. You're Lester Ballard. And Mr. Ballard, in cause number 24, DCCR 1882, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from July 8th of 2024. Your indictment alleges that you were previously convicted of the third-degree felony offense of stalking on June 11th of 2007. And after that was final, you were convicted of the third-degree felony offense of assault with bodily injury on a family member, and that's from October 22nd of 2010. What that means is that if you go to trial and you're found guilty, and those two prior convictions are true, then you would be considered a habitual offender with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand? You're charged. And I have with the second-degree felony offense of sexual assault of a child that has your signature on it with Mr. Parker's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty freely and that would be on count 1 only. Speak to count one only, which is the second degree felony because you did what they charged you with. That you're charged with. And I have here on the computer some documents that have your signature on them, which means that you would be leaving your punishment up to me. Before you sign more than 5 years, go over them with the plea agreement. I could give you 5. Do you fully understand? It would depend on the information that was brought to me. And do you understand if I follow the agreement you have every right to with the district attorney that you will be waiving or giving up any right to decide your punishment? I just want to make sure you understand what the possible consequences are if you go to trial and what your contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. And thank you. I have to ask everyone that. And did y'all fill out the
I'm just
okay?
thinking about that, just we did
All
not.
right.
Okay,
What do you
so
not understand? On these documents, there is some information about sex offender registration requirements. And do you understand that as a result of this plea, that you will be required to register as a sex offender? So hang on. Here's the thing. Also, there will be another document that you guys need to sign that just has that specific information on about what those rules are. So when we're finished today, you and Mr. Rojas need to go over that, and I'll just need your signature on that as well. You've told him these things about what happened. He's told Mr. Smith. Mr. Smith made his offer. That Mr. Watkins is not. You can either take it or let a jury decide. Mr. Watkins, I'm going to find that you entered your plea of guilty freely. I'm not going to get into the negotiations because that's not competent and you understand the nature. Also, don't want you to say anything on the record right now. Find sufficient evidence to find you guilty and at this time find you guilty of sexual assault of a child. So what I need to know is, do you want to accept that plea agreement for cap and 5 years, or do you want to let Texas Department of Corrections? You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That's what juries are for. I'm handing you the trial court certification that shows this was an agreement that I followed. Here's the thing, if you want to plead guilty, you're going to swear under oath that you're telling the truth. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Are you pleading guilty because of the judgment entered against you? You're ineligible under Texas law to possess a firearm or ammunition. So do you want to reject that offer? Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as we do not have any type of backlog here. If you have questions about the laws that make you ineligible to possess as quickly as we can possibly trial every single week. So you can talk to Mr. Rojas. Every trial gets a speedy trial as I can possibly get that. All right, that one more paper signed for me, okay? Thank you.
People say they've been 2 years in
There are different things in different cases that cause them sometimes to go longer. Sometimes it's a different court, sometimes it's just the facts of the case, sometimes it's DNA. But I can assure you that we will do it as quickly as we possibly can. Okay.
That's a big deal.
All right, so do you want to reject that offer and go to trial, or do you want to accept the offer? I don't get to, no, here's the thing. After today, if you place your case on the trial docket, my trial docket isn't somewhere where I put cases so that there's some more negotiation or you get a lesser deal later. Today's the day if you want to take a deal. If you don't, if it's on the trial docket, your choices are either going to be to plead open to me or to take it to trial. You're Lester Ballard, because that's how I keep my trial docket moving so that it doesn't get 24 DCCR 1882. You're charged with a second degree felony offense of aggravated assault with a deadly weapon. Okay, that's so July 8th of 2024. Take it or leave it. Your indictment alleges that you were previously convicted of. I want to make sure you understand what you're going to do and say on the June 11th of 2007. Okay, and after that was final, you were convicted of the third-degree felony offense. Either you did assault and you're guilty of it with bodily injury on a family member. You let a jury decide. And that's from You're not going to stand in front of me and say I didn't do it, but I'm just going to take a deal. What that means is that if you go to trial and you're found guilty and those two prior convictions go talk to your attorney about it and y'all let me know then you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years of life in prison. Do you understand? Yeah. And I have here on the computer a plea bargain rejection that has your signature on it with Mr. Parker's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And will your client waive the formal that would be on
reading of
count
the
one
indictment?
only.
He will, Your Honor.
To count one only, which is the second-degree
Mr.
felony,
Ballard, in cause
aggravated
number-
assault that you're charged with. Let's see, are we going on
and
count one?
it
It would be for a
Count one.
cap of
I'm
5
sorry.
years in
That's
prison,
okay.
which
Give me just a
means
second
you would
to,
be leaving your
make
punishment
this
up to me.
adjustment.
I couldn't give you more than 5 years if I accepted that plea agreement. I could give you 5, I could give you less. It would depend on the information that was brought to me at a sentencing hearing.
All
You have
right.
every right
The
to
state is
reject
elected
that
to
and have a
proceed in
jury
count
decide
one
if you're
only.
guilty or not, and then let
In
them
cause
decide
number
your
24,
punishment.
DCCR
I just want to make sure you
1882.
understand what the
It
possible
charges you with the
consequences are if you go
second-degree
to
felony
trial, and what
offense
your
of
options
aggravated
are.
assault with a
And do
deadly
you understand
weapon
all
from
of that?
July 8th of 2024. And how do you plead to that charge?
Are you
Okay.
pleading guilty freely and voluntarily? And because you did what they've charged you with.
Okay.
I have here on the computer some documents
Okay.
that have your signature
All right,
on
what do
them
you
that the
not
state has
understand?
marked as exhibit number 1. Before you signed these, did you go over them
Okay.
with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district
So
attorney?
hang on, here's the
that
thing.
you'll be waiving or
I'm not
giving
gonna
up
talk
any
to you
right
about
to
the facts
appeal?
of the case.
Also,
All
do
right,
you
so that's
understand
what
if
your
you're not a
attorney
U.S.
is for.
citizen that a
That's
plea
what
of
a
guilty
jury
or
is
no
for.
contest may
All this
result in your
information
deportation,
turns off and they're aware of
exclusion from admission to the
all this
country,
stuff.
or
Okay, so Mr.
denial
Parton,
of
you told
naturalization
him
under
these
federal law.
things about what happened. He's
State
told
tenders
Mr.
number one.
Smith.
Objection.
Mr. Smith's
It's
made this
admitted. Is there
offer.
any evidence that Mr.
You can either
Ballard is
take
not
it or let a
competent?
jury
Later on.
decide.
Right, so
We're
I'm going
not
to
going
find
to
that you entered your plea of
negotiate. I'm not
guilty
going to get
freely
into
and
the
voluntarily.
negotiations because
Find
that's
that you're
not the
mentally
time to do
competent
it.
and understand
I also
the
don't
nature
want
and
you
the
to say
consequences
anything on
of
the
that
record
plea.
right now.
Find sufficient evidence to
that
find
would
you guilty
potentially
and at
hurt
this
you
time
later
find you
in a
guilty of
trial.
aggravated assault with a
Okay,
deadly
so
weapon.
what I need
Sentence
to
you
know
in
is, do
accordance
you
with
want to
your
accept
agreement
that
to a
plea
term of
agreement
3
for a
years
cap
in
of
the
5 years, or
Institutional
do you want to
Division
let
of
a
the
jury
Texas Department of
decide?
Corrections. You will receive credit on that sentence for any time that you've been in custody
If you-
that the law
look,
gives
if you
you the
didn't
right
do
to
it, that's what
receive.
juries are for.
There is an affirmative
Right?
finding of a deadly
Okay,
weapon.
so don't, I mean,
I'm
you can't,
handing you the
if
trial
you
court
plead, here's the thing,
certification
if
that
you want
shows
to plead
this was
guilty,
an
you're going to
agreement
swear
that
under
I
oath that you're
followed,
telling
and
the
so you
truth.
have waived your
I'm
right
going to
to
ask you the
appeal.
question, are you pleading
I've also
guilty freely
handed
and
you a written
voluntarily?
admonishment
Are you
regarding
pleading
your
guilty because you did
ineligibility
it?
to possess
If
a
you didn't
firearm
do it,
or
then
ammunition.
that's what a jury's for.
Because of the judgment entered against
So do you want to
you're
reject that
ineligible
offer
under
and go to
Texas law,
trial?
to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term.
We do not
and you should
have
read
any
that
type of
written
backlog
admonishment I
here in
provide you
this
to see what
court.
devices qualify
Cases
as
are
a
getting
firearm.
tried as quickly as
If you
we
have
can
questions
possibly try
about the
them every
laws that
single
make
week.
you ineligible to possess a
every
firearm or
trial gets a
ammunition,
speedy
or about
trial
how
as I
long
can
that lasts,
possibly
you talk
give
to
it.
Mr. All right? All right. Good luck to you, sir. You can go back with the bailiff. All right, you're Christopher Bushnell. And so Mr. Bushnell has two
There are
cases,
different things
in
in
evading
different
arrest or
cases that
detention with
cause
a
them
motor
sometimes
vehicle
to go longer. Sometimes it's a
and
different
engaging
court.
in organized
Sometimes it's
criminal
just the
activity
facts
and
of
cause
the
numbers
case. Sometimes
25,
it's DNA.
0112 and 0113.
But I can assure you that we will
There
do
was
it as quickly
previously
as we possibly can.
an agreement.
All right, so do you want to reject that offer and go to
I'm
trial,
sorry,
or do
and
you
a
want to
plea
accept the
agreement
offer?
for 10-year deferred probation. We were here because
I don't
of the
get to-
issues in the
no,
jail. I
here's the thing.
rejected that.
After today,
because
if
if
you
I were
place
going
your
to
case
go
on
along
the
with
trial
that, I was
docket,
going to
my trial docket isn't somewhere where I put
the
cases
ISF,
so that there's some more
and so
negotiation, or
we're
you get a
back
lesser
here.
deal later.
And then, so
Today's
let
the
me
day if
ask
you want to take a deal.
I didn't even.
If you don't, if it's on the
What's
trial
bad is
docket,
when I
your
remember
choices are
stuff,
either
Mr.
going to be
Bushnell.
to plea
Your
open to
birthday's in
me
October,
or
right?
to take it to
No,
trial.
December.
Because that's how I keep my trial docket moving, so that it doesn't get too big and people aren't waiting on trial for a long time. Mr. Smith, is there any reason to believe
So,
that offer would change? Okay, so it's,
So we're
the
getting
offer is what
close.
it is. Take it or leave
But
it, what do
here's
you
the
want to do?
problem, Mr. Bushnell.
I want to make sure you understand what you're going to do and say on
So
the
you were here
record,
May
however.
6th, right?
Okay?
And I didn't accept these plea
No,
agreements.
there's no might as well
I got
take
pretty
it.
upset with
Either you
you
did it,
because of
and you're
what had been
guilty
going
of
on
it,
in jail, right?
or you let a jury
And what did I
decide.
tell you?
You're not going to stand in front of me and say, I didn't do
You know
it,
how many
but I'm just
write-ups
going
you've
to take a
gotten
deal.
since May
It
6th?
doesn't work that way. I can't allow you to do that.
You want to take a
Go
guess?
talk to your attorney about it, and y'all let me know
Too
what
many
you
to
want to do.
count.
I'll hold it for now.
Okay, too many to count.
Where's
May
Charlie?
6th.
Okay, Charlie,
You
y'all
got-
ready on escort?
Since then, 1,
Yeah.
2, 3.
All right, sir, you are Lester Ballard.
4, and
Looks like you've
5,
changed your
6,
mind and want to enter in a plea, is that correct?
7,
And will your client waive the formal
8,
reading
9.
of the indictment?
He will, Your Honor.
10, 11.
Mr. Ballard,
11
cause
more.
number,
Fighting, same thing.
let's see, are we going on count
Fighting,
one?
Count one.
not following
I'm
the
sorry.
rules.
That's okay, give me just a second to, make
Calling
this
names.
adjustment here. I mean, same thing, you don't like following rules,
The state is
do you?
elected to proceed in count one only You do?
In clause number 24,
What
DCCR
part of
1882, it charges you with
a
the second
correctional
degree felony
officer
offense of aggravated assault with a deadly
the
weapon
names that you've
from
been
July
calling
8th of 2024, and how do you plead to that
is
charge?
appropriate.
Are you pleading guilty
It's
freely and
not. So why would
voluntarily?
you keep doing it
And
after I
because you
told
did what they've charged you with.
I told you, go,
I
just
have
be
here on the
good
computer
for
some
a
documents
month.
that have your signature
1
on
month.
them
Be
that the
good.
state
Follow
has
the
marked as
rules.
exhibit number 1. Before you
And it's
signed
one
these,
thing
did you
if
go
you've
over
got
them with Mr.
another
Parker?
inmate running up
Do you
on
fully
you fighting,
understand
that was your excuse.
And do you understand
But
if
it's
I
not.
follow the agreement that you've made
Not
with the
accepting
district
any of plea
attorney,
agreements.
that you'll be
If
waiving
the
or
jury
giving
wants
up
to
any
see all
right
this
to
and give you
appeal?
probation after that, that's
Also,
gonna
do
be
you
up to them.
understand if you're
I'm
not a U.S.
doing it.
citizen,
Go
that a
back
plea
with
of
the bailiff,
guilty
we'll
or
set
no
your case for-
contest
well,
may
let me
result
do
in your
this. Ms.
deportation,
Holmes
exclusion from
has been
admission to the
appointed as your
country,
attorney.
or denial of
And
naturalization
she's one of the
under
attorneys who
federal law.
handles a lot of cases for me as a
State
court-appointed
test number
attorney.
one.
What I
It's
can do
admitted. Is there
is
any evidence that Mr.
release
Ballard is
her
not competent?
and appoint a new attorney who
All right,
can
so I'm going
begin
to find
preparation
that you
for
entered your
trial.
plea of guilty
Do
freely
you
and
want me to do that?
voluntarily. Find that you're mentally competent
Or
and
do you wanna keep
understand the
Ms.
nature and
Holmes?
the consequences of that plea.
All right, Ms. Holmes, get
Find
ready for
sufficient
trial.
evidence to find
And
you
let me tell
guilty,
you
and at
what
this time
you're
find you
doing.
guilty
You're
of
making
aggravated
her
assault with a deadly
job
weapon.
hard.
Sentence you in accordance with your agreement to a term of 3 years in the
She's trying to
institutional
help me.
division of the Texas Department of
I wanted
Corrections.
to try to help
You will receive credit on
If
that
you
sentence
came in
for any
today
time that
and
you've been in
didn't have all
custody
this
that the law gives you
nonsense,
the right to receive.
calling,
There is an
I'm looking
affirmative
at it
finding
over and
of a
over,
deadly weapon.
calling them
I'm
the
handing
B
you
word.
the trial court certification that shows
Not
this
doing
was
what
an
you're
agreement
supposed to,
that I
saying, "I don't
followed, and so
care."
you have waived
Write
your
me up,
right
"I
to
don't care."
appeal. I've also handed
If you
you a
don't care,
written
then I don't
admonishment
care.
regarding your
Because I
ineligibility to
tried
possess
last
a
time we
firearm
had this
or
conversation.
ammunition.
So your case is going on the
Because
trial
of the
docket.
judgment entered
and
against
again,
you,
we'll let
you're
the jury decide
ineligible
what to
under
do with
Texas
you.
law
Go back with the bailiff.
to possess a firearm or ammunition. Possession of a firearm or ammunition could
Where you
lead
have
to
a
charges
warrant.
against you. Firearm is a legal term, and you
Good
should
morning.
read that
Are
written
you Marissa
admonishment I
Tibbetts?
provide you to see what devices
And,
qualify as a firearm.
will your client waive the formal
If you have
reading of the
questions about
motion
the
in each
laws
of her
that make you
cases?
ineligible to possess a firearm or
Okay, Ms.
ammunition,
Tibbetts,
or about
in
how long
clause
that
number
lasts, you can talk to Mr. Parker.
1828,
All
well,
right, good luck
before
to
we
you,
do
sir.
that,
You
raise
go
your
back
right
with the
hand the
bailiff.
best you can,
All right, you're
please.
Christopher
Do you
Bushnell.
swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
in evading arrest or detention with a
Put your
motor
hand down.
vehicle
And,
and
Ms. Tibbetts,
engaging in organized criminal activity.
Excuse me.
And cause numbers 25,
have a,
0112, and
cause number
0113.
28754. There was previously
I have a motion to revoke your unadjudicated probation.
an agreement.
Shows that you were placed on
motion-
probation.
I'm
October
sorry, and a
29th
plea
of
agreement for 10-year
2018
deferred
for the offense
probation.
of aggravated
We were here
robbery, a first-degree
because
felony,
of the
and that was
issues
a
in the jail.
10-year
I
deferred
rejected
probation.
that.
Is that correct?
Because if I were going to go along with that, I was going
And
to
then in clause number 18,
order the
28753,
ISF.
I also have a motion to
And
revoke
so
your
we're
unadjudicated
back
probation.
here.
It shows you were placed on
And then-
probation
so let
October
me
29th
ask
of 2018
you-
for aggravated robbery, a first-degree
What's
felony.
bad is when I remember
Again, that was
stuff.
a 10-year
Bushnell.
deferred probation.
Your birthday's
Is that
in October,
correct?
right?
No,
Each of
December.
these motions allege that you violated your probation. Count one in each motion alleges that you committed the offense of burglary of
So,
a building March 22nd of 2025
so
in
we're getting
Jefferson County,
close.
Texas. And is that true
But
or
here's
not
the
true?
problem, Mr. Bushnell.
Count two in each case alleges
So you were
that
here
you
May
provided a
6th.
urine sample
Right.
March 18th of
And
2025.
I didn't accept these plea
that tested
agreements.
positive for
And I got pretty
methamphetamines and
upset with
marijuana.
you
And is that true
because
or not
of
true?
what
had been going on in jail, right?
True
And what
or
did I
not
tell
true?
you? Count three in each of the
You know how many
cases
write-ups
alleges
you've
that
gotten
you were
since
at a
May
location
6th?
other than your residence at
You
11:15
wanna take a guess?
p.m. March 22nd of
Too many to
2025. And is that true or not true? I'm sorry?
Too many to count.
Okay.
May 6th.
Count four
You
in
got-
each case alleges
since
that
then,
you are behind
one,
in your court assessed fees, and
two,
it's just
three.
a little bit in each case, $29
Four.
in one and $37 in the other. Is that true or not true?
5, 6,
Did you enter your pleas of true in each of
7,
the cases to counts 2 and
8,
4
9,
freely and voluntarily?
11.
The counts that you pled true
11
to, 2 and
more.
4, did you do that
Fighting,
voluntarily?
Same things.
And did you plead
Fighting,
true to those
not
counts
following the
because those two
rules.
are actually true? All right, then I'm
Calling
going to find that you
names.
entered your pleas of true to counts 2 and 4 freely
mean,
and voluntarily.
same thing.
Find those counts true, find sufficient evidence in each case to find you guilty and revoke your probation, but
You
I'm
don't
not
like
going to do
following the
that
rules, do
today.
you?
I'm going to reset your cases for a
You
hearing.
do?
The state on
What
that day,
part
if they
of
want,
calling
can put on evidence with regard to
a
any other
correctional
allegations.
officer
And anything that you think
the
is
names that
important
you've
for me
been
to know,
calling
get that information to Mr. Kimmler. He will present it to me
appropriate.
on your behalf when we come back.
It's
I'll also
not.
get
So why would
probation
you
to do an
keep doing
updated
it after I
report as
told
well.
you?
All right, you can go back
I
with the
told
bailiff.
you, go, just be good
This
for
is
a
deferred heard, I think
Month.
the court has said.
1
bonds in
month.
the
Be
case
good.
is
Follow the
relatively
rules.
high. I believe they're
Do you want to file a motion
And
for,
it's
if
one
I've already
thing
had a
if you've got
hearing with another attorney, I don't,
inmate running
unless
up
there's
on
some
you,
change in
fighting, that was your
circumstances, I don't.
excuse.
We're not
But
going to
it's
do that
not.
today for sure. But I would
Not
need some
accepting
change
any
in
plea agreements.
circumstances if I've already had a
If the jury
hearing.
wants to see all this and give you probation after that, that's gonna be up to them. I'm not
You're
doing
going to
it.
get the same
Go back with the
reset
bailiff, we'll set your
on a
case for-
motion
well,
that we
let me
get
do
so
this.
that everybody
Ms.
can get
Holmes
prepared and so that
has
that
been
updated
appointed as
report
your
can get taken
attorney,
care of.
and she's one of the attorneys who
morning,
handles
sir.
a
You
lot of
David
cases for me as a
James?
court-appointed attorney.
And Mr.
What I
Parker,
can
will
do
your
is
client waive the formal reading of
release
the
her
indictment and the motion?
appoint a new attorney who can begin
Mr.
preparation
James,
for
in
trial.
clause number
Do you want me to do that?
250522, you're charged with the
Or do
third-degree
you wanna
felony
keep Ms.
offense
Holmes?
of collision involving serious
All right, Ms.
bodily
Holmes, get ready
injury
for trial.
from February
And let me tell you
16th of
what you're doing.
2025.
You're making her
And
job
how do you plead to that
hard.
charge?
I plead, no contest.
She's
You
trying
either
to
did it or
help
you didn't do it.
I wanted to try to help
Are you pleading guilty
If
freely
you came
and
in today
voluntarily?
and didn't have all this
And are you pleading guilty
nonsense,
because you actually did what they
calling,
charged
I
you
mean, I'm
with?
looking at it over and over.
All right.
Calling them
Then I'm going,
the B
I have here
word.
on the computer in that case, some documents that
Not
have your
doing
signature
what
on
you're
them that the
supposed to,
state
saying,
has
"I
marked
don't
as exhibit
care."
number 1.
Write me up, I don't
Before you
care.
signed these, did you go over them
If
with
you don't
Mr.
care,
Parker?
then I don't care.
Do you fully
Because
understand
I tried
that?
last time when we had this conversation.
And do you
So your
understand
case
if
is
I
going on
follow
the trial
the agreement
docket,
that you've
again,
made
we'll
with the
let a jury
district
decide what
attorney
to
that
do
you
with
will be
Go back
waiving
with
or
the
giving
bailiff.
up any right to appeal?
Right, yes.
And it looks like the agreement that you've
Where you have
reached
a
is for a
waiver.
10-year term in prison, but that would be probated.
Good morning.
You'd be
Are
on
you
probation
Marissa
for 5
Tibbetts?
years.
And, will your
and that-
client waive the formal reading of
Is
the
that your
motion in
understanding of
each
your
of her
agreement?
cases?
She would, huh?
The other cases.
Ms. Tibbetts, in clause number 18,
Extended
28, well,
probation and
before we do
safety
that, raise your right
relapse.
hand the best you can, please.
Okay.
Do you swear or affirm the testimony
I
you're
guess
going to
the-
give in this
the
hearing
length
will
of
be the
time
truth,
in
the
the
whole truth,
probation
and nothing but the
is
truth?
something that
Thank you. You can put your
obviously
hand down.
the length of
And,
time on your
Ms.
probation,
Tibbetts,
because it's,
Excuse me.
it's even written on
I
here.
have a,
On this one,
in clause number
I can,
18,
I can give you any amount of time on
28754, I have a
probation, so
motion
I don't
to
have to
revoke
follow
your
that
unadjudicated
5 year. If I
probation.
give you the probation.
Shows that you were placed on probation
And sentence you
October
to
29th
probation,
of
the 10-year term in
2018 for the
prison,
offense of
probated
aggravated
for any
robbery,
number
a
of years,
first-degree
you
felony.
understand
And that was a
that,
10-year
you'll
deferred
be waiving your
probation.
right
Is that
to appeal.
correct? So the thing
And then in
is,
clause number 18,
until I see an updated pre-sentence report and really see what's been going on,
revoke your unadjudicated probation.
just on the face
It
of
shows
this,
you were placed on
it
probation
makes me
October
have a little bit of
29th of
pause
2018
because you're
for
already on a
aggravated
felony
robbery, a
probation.
first-degree felony.
And
Again,
there's
that
a
was a
new
10-year deferred
felony
probation.
offense.
Is that correct?
And so
Each
I'm
of
not
these
sure
motions
that
allege
the
that you
length of
violated your
time of
probation.
only 5 years is something
Count
that I'm
one
willing to
in
go
each,
along with, but I'll take a look
motion
at it when we
alleges
come
that
back
you
for
committed
sentencing. Do
the
you understand?
offense of burglary of
You
a
know, I've
building
explained that to him, and
March
I've explained to him
22nd
that
of
some courts
2025
don't
in
even
Jefferson
consider
County,
that. They
Texas.
automatically
And is
do
that
10.
true or
But
not
if you do what you're
true?
supposed to do, the judge can always let you off probation early.
Count
Correct.
2 in each case alleges that you provided
Do you
a
also
urine
understand if you're not a
sample
U.S.
March
citizen that a
18th
plea of
of
guilty or no
2025
contest may
that
result in your
tested positive for
deportation,
methamphetamines
exclusion
and
from admission to the
marijuana? And is
country,
that true
or
or not
denial
true?
of naturalization under federal law?
Stating
True
there's
or
number
not
1 in
true?
that
No
case.
objection.
It's admitted.
Count 3
Is there
in
any
each of
evidence
the
that Mr.
cases
James
alleges that
is
you were at a
not
location
competent?
other than your
All right,
residence
sir, in
at
25:05:22, I'm going to find that
March
you entered the plea
22nd
guilty
of
freely and
2025.
voluntarily.
And is that true
Find that
or
you're
not
mentally
true?
competent
I'm
and
sorry?
you understand the nature
Okay.
and the consequences of your
Count
plea.
4 in each
Find
case
sufficient
alleges
evidence to
that
find you
you
guilty.
are
However, I am
behind
going
in
to
your
reset your
court
case so that
assessed
the
fees, and it's just
probation
a little
department
bit
can
in
do a
each case,
pre-sentence report.
$29 in
Give
one
me
and
an
$37
update,
in the
obviously,
other.
on
Is
the
that true or
probation
not
case
true?
as well as more information
Did you enter
on
your
this
pleas of true in
offense, and
each
then
of
we'll
the
come back
cases
later
to
for
counts
sentencing.
2 and 4
Now,
freely and
in clause number
voluntarily?
15, 2, 3,
The counts that you
5,
pled
4,
true to,
5.
2 and 4, did you do that voluntarily? And did you plead true to those counts because those 2 are actually true? All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to
I have
find
a
you
second
guilty and
amended
revoke your
motion to
probation,
revoke
but I'm
your
not going to do
unadjudicated
that
probation.
today. I'm going to reset your cases for
Shows that you were
hearing.
placed on probation.
The state on that date, if they want, can put on evidence with regard to any other allegations.
November 13th
And
of
anything that you
2017
think
for the
is
offense
important
of
for me
burglary
to
of a
know, get that
habitation,
information to
second-degree
Mr. Kimler.
felony.
He will
And that
present
was
it
a
to me on your
10-year
behalf
deferred
when we come
probation.
back.
Is that correct?
I'll also get probation to
This
do an
motion
updated
alleges
report
that you
as well.
violated your
All right,
probation.
you can go back with the
Count
bailiff.
1 alleges that you committed the
This
new
is
offense
deferred.
of
I think
possession of a
the court has
controlled
set bonds
substance,
in the
February
cases that are
3rd
relatively high, I
of
believe.
2025
Do you want to file a
in
motion
Jefferson
for,
County,
if I've
Texas,
already
and is
had a
that true
hearing
or not
with another
true?
attorney. I don't, unless there's some change of circumstances, I don't,
Count
we're not
2
going to do that
alleges
today for
that,
sure.
you
But I
committed
would
the
need some
offense
change
of possession of drug
circumstance if I've already had a
paraphernalia
hearing.
on February
We need to
3rd,
reset
2025, and is that
We
true
get
or not
speedy
true?
reset now.
You're going to get the same
Count 3
reset
alleges that
on
you
a
failed to
motion that
avoid
we get so
persons or
that everybody
places of
can get
disreputable
prepared
or
and so that that
harmful
updated
character.
report can get taken care of.
Specifically,
I'll be out to see you.
good morning, sir. Are you David
By
Wayne
associating with
James?
past
And
associates
Mr.
who are
Parker,
actively
will your,
using illegal
client waive the
substances.
formal
Is
reading
that
of the
true or not
indictment
true?
and the motion?
Yes, Your Honor.
Mr. James,
Count
in cause
4
number
alleges that you
25,
provided a urine sample September 23rd,
you're charged with the third-degree
2024
felony
that tested
offense of
positive
collision
for
involving
cocaine.
serious
Is that
bodily
true or not
injury.
true?
From February 16th of
Count 5
2025.
alleges that you provided a
And,
urine sample
how do
January
you plead that
27th of
charge?
2025 that tested positive for methamphetamine.
You either
Is
did
that
it or you
true
didn't do
or
it.
not true?
Please, yes.
Are you pleading guilty
Count 6
freely and
alleges that you felt-
voluntarily?
Nope,
And
we're
are you
gonna keep
pleading
going. I
guilty
wanna know
because
all
you
of this
actually
if I'm
did
gonna
what they
consider
charged
leaving
you
them on
with?
probation. Thank you, though.
All right. Then I'm going,
Count 6
I have
alleges
here on
that
the
you failed
computer
to
in that
abstain
case some
from the use of
documents
any
that have your signature on
non-intoxicating
them that the
substances,
state has
including
marked as
alcohol,
exhibit number
and that
1.
you provided a urine
Before
sample
you
on
signed
February
these,
3rd
did
of
you go over them
2025
with
that tested
Mr.
positive for
Parker?
alcohol.
Do
Is
you
that
fully
true or not
understand
true?
that?
Yes.
And do you
Count,
understand if I
7
follow the
alleges that
agreement
you're
that you've
behind
made
in
with
your
the
court
district
assessed
attorney that
fees
you will be waiving
as
or
of
giving
February
up any
3rd,
right to
2025
appeal?
in the amount of
And it looks like the
$1,689. Is
agreement
that
that
true
you've
or not
reached is
true?
for a 10-year term in prison, but that would be
Count 8
probated. You'd be
alleges
on
that,
probation for 5 years. And that, is that your understanding
That
of your
doesn't really
agreement?
give me,
The other case
All right,
is-
I'm gonna skip 8.
If you can't read my writing, it's extended probation and
count
safety
9
relapse.
alleges that you failed to report to the probation department as directed
I
on
guess
February
the
7th of
length of time in the
2025. Is
probation
that true or
is
not
something
true?
that, obviously, the length of time
Count
on your
10
probation.
alleges that you were at a location other
because
than
it's-
your residence
it's even
at
written on here.
approximately
On this one,
11:51 p.m.
I can,
February
I can
16th
give
of
any amount of time in
2025. Is that
probation,
true
so I
or
don't have
not
to follow
true?
that 5-year. If I give you the probation, and
Count
sentence you to
11
probation,
alleges
the
that you
10-year
failed
term in
to
prison,
submit
probated
to the
for any number
alcohol
of
or
years,
drug
you
screening
understand
as directed.
that, you'll be
February
waiving your right
11th,
to appeal.
February 14th, and February 19th of 2025. Is that true or not true?
Until I see an updated pre-sentence report and
Count
really see
12
what's been
alleges
going
that you
on,
committed that new offense
just on the
of
face
an
of this,
collision involving
it
serious
makes me
bodily
have a
injury,
little bit of
February
pause
16th of
because you're already on a
2025.
felony
Is that true or
probation.
not true?
And there's a new
Did you enter
felony
your pleas of
offense,
true to all of the
and
counts
So
except-
I'm not sure that the length of time of
Let's see,
only 5
8,
years
which
is
is the one
something
that I
that I'm
left
willing to
out,
go along
freely
with,
and
but I'll take a look
voluntarily.
at it when we come back for sentencing. Do you understand?
And did you plead true to all of those
Your Honor,
counts
I've
because
explained
they're
that to him,
actually
and I've
true?
explained to him that some courts don't even consider that, they
I
automatically
have
do
here
a
on the
10.
computer some
but if you do everything you're
documents
supposed
that
to
have
do,
your
the judge
signature
can
on them
always
in this
let you
case
off
as
probation
well.
early.
Again, did you go over
correct.
these with Mr. Parker? Do you also understand if you're
fully
not a U.S.
understand
citizen
them?
that a plea of guilty or no
You
contest
understand
may
if I
result
follow
in your
the agreements
deportation
that you've made
exclusion
with the
from
district
admission to the
attorney that you
country,
would be
or
waiving or
denial of
giving up any right
naturalization
to
under
appeal?
federal law?
Yes, yes.
And it looks
State
like the
Tennessee
agreement in
one,
this
and
case
that's
would be for me to
It's admitted,
continue
and
your
is there any evidence
probation,
that Mr.
extend
James
it for
is
2
not
years, and
competent?
order you to the safety
Right, sir,
relapse
in
program. Is that your understanding?
25-0522,
I'm going to find that you entered your
State
plea
Tennessee
guilty
number
freely
1.
and voluntarily.
objection.
Find that
It's
you're mentally
admitted.
competent
All right,
and
so
you
I'm going to
understand the
find that you
nature and
entered
the
your pleas of
consequences of your
true
plea.
to counts
Find sufficient
1 through
evidence to
12,
find you guilty.
minus
However, I
8,
am going to
freely
reset
and
your case so that the
voluntarily. Find
probation
those
department
counts
can do a
true.
pre-sentence
Find
report.
sufficient evidence
Give me an
to find
update,
you
obviously,
guilty
on the
and revoke
probation
probation,
case
but
as
I'm not
well
going to
as
do that
more
today. I'm going to
information
reset
on
your
this
case.
offense, and then we'll come back
Again,
later
to get
for
an updated
sentencing.
report about this case as
Now,
well as
in
cause
a
number
report about the other
15,
case, and we'll come back at a later date for
23-545.
sentencing. All right, you can go back with the bailiff.
Thank you.
Yes, sir.
And Mr. Sanchez is currently on probation for the offense of driving while intoxicated, third or more. A motion to revoke was filed with the allegation that there
I have a
was
second amended motion to revoke
a
your
new
unadjudicated
offense of
probation.
driving while intoxicated from April
Shows that you were
15th
placed
of
on
this year
probation.
in Wharton. Is that Wharton County or anyway? it's in
November
Texas.
13th of 2017
And then,
for the offense of burglary of a
also that
habitation,
on April
second-degree
15th,
felony.
2025,
And that was a 10-year
he was driving a
deferred
vehicle
probation.
that
Is
was
that
not
correct?
equipped with an ignition
This
interlock
motion alleges
device,
that you violated
and
your
that he failed to
probation.
abstain from
Count
the
1
use of
alleges that you
alcohol,
committed the new offense of
possession of a controlled substance, February 3rd.
Mr.
2025
Franklin
in
has
Jefferson County,
filed
Texas.
a
And
motion
is that
asking
true
that
or
I
not
set a
true?
bond. There's currently not a bond on the motion to revoke probation.
Count 2 alleges that you
intend to
committed
call
the
your client as a
offense of
witness?
possession of drug paraphernalia on
Only
February
if
3rd of
necessary, Your Honor.
2025, and is that true or not true?
Go ahead, and I'm trying to find.
Count 3 alleges
Give me
that you
just a
failed
second.
to
I'm
avoid
looking for the
persons or
old
places
PSI.
of disreputable or harmful character.
My copy's needed, Your Honor.
Specifically, This one
by
may be old enough
associating
where it
with
didn't
past
get.
associates who are actively using illegal substances. Is that true or not true?
It was 2019.
Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true?
Okay.
Count 5
you can go
alleges
ahead.
that
Your
you
Honor,
provided
we've
a
not
urine
provided
sample
a copy
January
of the
27th of
PSI. That
2025
was not
that tested
produced to
positive
us.
for methamphetamine. Is that true or not true?
So that was one of the issues, I think.
Count 6 alleges that you
in
failed,
addressing
we're
the-
gonna keep going. I wanna know all of this if I'm gonna consider leaving them on
We also
probation.
supplied-
Thank you, though.
Right up.
Count 6 alleges that you failed to abstain from the use of any and all
We filed
intoxicating
with our
substances,
motion
including
about
alcohol,
a
and
dozen
that you provided a
letters in
urine
support.
sample on February 3rd of
And I have
2025
received
that
those and
tested
take judicial
positive
notice
for
that the court's
alcohol.
filed
Is
that
that
includes
true or
those
not
as well.
true?
Thank you.
Thank you, Your Honor.
Count 7 alleges that you're behind in
assessing,
your court-assessed fees
whether
as of February
Ms. Sanchez
3rd,
is a flight risk,
2025, in the
I
amount of
think the support from this
$1,689. Is that
family
true or not true?
Help provide evidence that he's not a flight
Count
risk.
8
So the
alleges
court
that,
should then turn to the prong of whether, of what threat he
doesn't
may
really,
pose to
give me-
himself or others.
all right, I'm gonna skip 8.
In this case.
Count 9 alleges that you failed to
the
report to the probation
underlying
department as directed on
offense was
February 7th
2019.
of 2025, and is that true or not true?
The motion was filed based on
Count 10 alleges
A
that you were at a
violation,
location
true,
other
but
than
there
your
were not other
residence at
violations
approximately
as far
11:51
as
PM,
not reporting
February
or filling
16th
in
of
the test up until
2025.
now,
Is that
so
true
that's
or not true?
been Effectively 6 years. He's been
Count
compliant.
11
We'd also-
alleges that you
we'd
failed
also like
to
the
submit
court to
to the
take note
alcohol or
that
drug screening
the
as
other
directed.
offenses that are
February
mentioned
11th,
goes
February
back as
14th,
far
and
as
February 19th of 2025. Is that true or not true?
2000, et cetera. In other words,
Count
it's
12
been,
alleges that you committed
in some
that new offense
instances,
of an collision involving serious
since
bodily
those
injury,
offenses
February 16th of
occurred.
2025. And is
And
that true or not true?
Although we're not downplaying the
Did you enter your
severity
pleas of
what
true to all of the
Sanchez
counts
is currently
except,
charged with, we do think the court should take into account
let's see, 8,
as
which is the one that I
regards
left
the
out,
threat to
freely
himself or
and
others, the fact that
voluntarily?
the other causes
And did you
are,
plead true to all of those
in
counts
some
because they're
instances,
actually
over 30
true?
years.
What's the status of that?
I have here on the computer
case
some
in Wharton.
documents
Does
that have
anybody
your
know?
signature on them
Your
in
Honor,
this
it-
case as well.
My understanding, and
Again,
I
did
don't
you go over
represent him on
these
that
with
case, but my
Mr.
understanding is
Parker?
that it is
Do you
pending.
fully understand them?
Because this one.
You understand if I follow the agreement that
fell
you've
first
made
in the queue,
with the
so
district
he was
attorney
sent
that you would be
first.
waiving or giving up any
So they're
right
gonna
to
wait for us
appeal?
to see what I do, huh?
That
And
is
it looks
my
like the
understanding,
agreement
Your
in
Honor,
this
but again,
case
I don't
would be for me
represent him on that,
to
but that's
continue
what
your
I
probation,
could
extend it for
glean.
2 years
I spoke
in
to a
order
lawyer
you
that
to
he
the safety
conferred with there,
relapse
but he did not end up
program. Is
hiring
that your
that lawyer, so he
understanding?
couldn't speak
State
No.
tenders number
Okay.
1.
No objection.
All right,
It's
Mr.
admitted.
Nichols, what's the
All right,
state's
so I'm
position
going
with
to find
regard
that
to
you
entered your pleas of
Judge,
true
my main
to
concern is in
counts
driving.
1 through
vehicle that
12
doesn't have an interlock,
minus
so we have no
8,
idea how
freely
much,
and voluntarily.
driving
Find those
is done.
counts
Sounds
true.
like the only reason
Find sufficient
we found out
evidence
about
to
this
find you
violation is that
guilty
he
and
can
revoke
get
for probation,
caught.
but I'm not going to do that today. I'm going to
I
reset
doubt
your
that
case.
this is a one-time event of
Again, to get an
driving his
updated
wife's
report
vehicle
about
without an
this
interlock.
case as well as
And so,
a
to
report
protect
about the other
community,
case, and we'll
I
come
asked
back
if
at a
the
later
court
date for
set a bond, that'd be
sentencing.
high enough to
right, you can go back with the
protect me
baby.
from his repeated driving while intoxicated.
Yes, sir. And
Your Honor, may
Mr.
I-
Sanchez
First-
is
first-
currently on probation for the offense of driving while
Speculation
intoxicated, third
as
or more.
regards any
A
other
motion to
instances is
revoke
probably
was
not
filed
admissible.
with the allegation that there was
There are
a new
measures
offense
that the
of
court
driving
can
while
take
intoxicated from
in
April
assigning bond
15th of this
conditions
year
to
in Wharton.
monitor, Mr. Sanchez
Is that
in
Wharton
such a
County
way
or?
that he.
But
Anyway,
he had
he was
probation
checking
conditions that were meant
And
to
then,
monitor him. Also that
Your
on
Honor,
April
as
15th,
regards,
2025,
whether he's
he was
drinking,
driving a
for
vehicle
example,
that was not
there
equipped
are
with an
SRAM
ignition
devices,
interlock
devices that
device,
constantly
and
test
that he failed
for
to
alcohol
abstain
in the
from the
system.
use of alcohol.
SRAM device, for example, tests I think it's every half hour.
Yeah, so here's where I am on
Mr.
this.
Franklin
Mr.
has
Sanchez
filed
a motion
had
asking
a
that at
set
least,
a
this is
bond.
his
There's currently
fourth
not a bond on the
conviction that
motion
we
to
know
revoke
of
probation.
for a DUI. I know there
Do
were
you
some
intend to
other
call your
arrests
client as a
that we
witness?
didn't have the
Only
disposition.
if necessary, Your
Looks
Honor.
like, at least according to
Go
some,
ahead, and I'm trying to
some of the information I've received, that there's
Give me
been
just a
7 or
second.
8
I'm looking for
arrests.
the old PSI.
This was a
Object to
cap.
Including those
I
as
have
well, Your Honor.
my copy. if you
Okay,
need it,
that
Your Honor.
it's overruled. They
This one may be old enough where it didn't.
think with
get-
regard to setting bond, under 17.15, I'm able to take into consideration
It was
everything that
2019.
is at my disposal, and in fact, I'm required to take into account everything that is at my disposal with regard to prior offenses, with the
Okay.
most recent bail
All right,
reform,
you can go ahead.
as
and
well
Your
as
Honor, we've
the
not been provided with a
ones
copy
from
of
a
the
couple
full
years ago.
PSI.
So,
That was not produced to
the-
us.
my
I guess my worry
So that was
isn't
one of the
necessarily
issues, I
the
think,
reporting
that,
or him
he's
pleading. My
addressing
concern is
the-
for the safety of the community. And
We also
this was a
supplied
cap of 8
right
years when I gave him this probation,
Go ahead.
probably
We supplied,
against the
we filed
argument
with our
of counsel
motion
from the
about a
state.
dozen letters of
And gave him this
support.
opportunity. He's on probation.
have received
commits
those
another.
and
We're
take
lucky
additional
we're not
notice
here
of
for
the
court's
court's
file that
file
includes
or
those
even
as well.
worse. Thank you.
I am
Thank
going
you,
to
Your Honor.
deny the motion for a bond at this time. If there is
assessing
any likelihood at all that I
whether
would leave Mr.
Mr.
Sanchez
Sanchez
on
is a flight
probation,
risk, I
it
think
would
the
absolutely be
support
with some
from his
type
community,
of
from his
treatment.
family,
And so I'm not going
help
to allow
provide
him to
evidence
get
that he's
out
not a flight
and
risk to the court.
even with the scram or
Then
anything
turn
else and
to
put
the
the
call.
community
Of whether,
in danger. All right,
what threat
we'll
he may
get it set
pose
for an
to
announcement
himself or
within
others.
about 30 days or so, and then we'll see where we get on the case.
Thank you, Judge.
Thank you, sir.
In
You can go
this
back with the
case,
bailiff.
The underlying offense was 2019.
Good morning, ma'am. Are you Ebony
The motion was
Broussard?
filed based on
And
a
Ms.
violation,
Broussard is
true,
on
but there were not other
probation
violations
in cause numbers 19
as far as not reporting
32518,
or filling other tests up until now, so that's been effectively
1932-806,
6
and
years.
21-36615
Compliant.
for the offenses
And also,
of escape
we'd
while
also like the
arrested,
court to take
assault
note
on a
that
peace officer in possession of a
the other
controlled
offenses
substance.
that are
There's been motion to
mentioned
revoke filed
go
in all
back
3 of
as
those
far as
cases. And Mr. Nix, what is the
1992.
announcement?
Your Honor,
Two
I've spoken with the
1995,
state. I think we have something in the works.
It's been,
I think
in
we
some
both like a
instances,
2-week reset.
decades
And I
since
think
those
in
offenses
2 weeks,
occurred. And
offers that
although
we
we're not
made to the
downplaying
state to try to
the
resolve these
severity
issues would be made whole at that time, and I
Sanchez
think this will
charged
be worked
with,
out
we
at
do
the
think the
2-week
court
reset.
should take into
Any issue,
account
Ms. Malfino?
as regards the threat to himself or others, the fact that the other
With this
clauses
defendant
are
for a long time now, of
some
course,
instances
respect
are
her
years.
position. Ultimately,
What's the status
in
of
she
that,
is the one who
case
actually
in
works with
Wharton?
her.
Does anybody
There's
know?
quite a bit
Your Honor,
of
it is,
years to this
my
case.
understanding,
Ms.
and I don't
Broussard has
represent
been
him on that
ordered
case, but my
previously to pay
understanding
those
is that it is
forms of
pending
income, such as your tax
because
return,
this
et cetera,
one,
is with your client and doing that to the probation
fell first in the
department.
queue, so he was sent
Mr.
here
Nix
first.
indicates that she.
So they're gonna wait for us to see what I do.
That's my understanding, Your Honor, but again, I don't represent him on that, but that's what I
That time to maybe see where we
gleaned.
are.
I spoke to a lawyer that he conferred with there, but he did not end up hiring that lawyer, so he couldn't speak
If she does not get
Okay.
that paid, we may just go ahead.
All right.
He thought it was just another day in court, but what happened next changed everything. One wrong decision, one moment of truth, and suddenly there was no escape. The room went silent. No whispers, no movement, just tension in the air. The judge looked straight at him, and in that second, you could feel it. This wasn't going to end well. No second chances, no sympathy, just consequences. What he said next shocked everyone in the courtroom, and when the sentence finally came down, even he couldn't believe it. This is the moment everything fell apart.